Hello and welcome to this lecture on the American court system. Today we're going to be talking about the structure of the U.S. court system and the California court system, and we'll also be talking about the U.S. Supreme Court. So let's go ahead and get started and jump right into the lecture. Welcome back to this lecture on the court system, part one. I'm going to go ahead and jump right into it here. So before we get into the structure of the court system, it's important to recognize the terms that come along when we talk about the judiciary system. So first of all, we have two types of law. We have criminal law, which regulates the conduct of individuals, crimes, specifies punishments for criminal acts. So for instance, grand theft auto, homicide, assault, that's all going to be under criminal law. And when that happens, the government is always the plaintiff, which is the party that brings the case before the court. That would be the prosecutor. So in that case, the government is always going to be the plaintiff. If somebody commits a crime, another person, another individual, does not become a plaintiff. They cannot bring that case. Now, they can push government to bring charges and to act as the prosecutor, but government's always going to be the plaintiff in criminal law, whether it's at the state level or the federal level. Defendants are going to be the people who are on trial. And if they're found guilty in a criminal case, they are usually fined or they have to be sent to jail or prison. Now, civil law is different. This has to do with financial issues. There are disputes that do not involve criminal penalties, and typically, in this type of law, private individuals can bring cases against one another. Let's go ahead and move on here. Some other important terminology. When courts are bringing people, or actually, let me rephrase that. When governments or people are bringing forward cases, courts are going to apply existing laws and legal precedents, and there's kind of a difference between those. So let me talk a little bit about precedent first of all. Basically, this is prior cases whose principles are used by judges as a basis for their decision in the present case. So this actually goes all the way back to the Middle Ages under a system known as common law in England. Basically, under feudalism, you kind of had this network of warlords who all were loyal to the king. And in each of the different regions within England, you had magistrates, and those magistrates were bound also to the king. And what would happen is a magistrate would rule in a case, and they would cite something that another magistrate had done as justification for issuing that ruling. So that's how our system is built. Not only is it based upon laws that the legislative branch passes. So, for instance, if the legislative branch were to make it illegal with a penalty up to 20 years to commit arson, start forest fires, okay, that would be a statute. That's where the legislature has essentially said, here is the penalty, this is illegal. But precedent is where over time, judges at the margins will change how the law is interpreted based on their rulings. And typically, just like how you cite something in a paper, you're going to cite evidence. Judges use precedent as evidence to base their rulings. And this is known as the doctrine of stare decisis, which means literally let the decision stand. They're letting it stand on precedent, on previous cases. Okay, so we especially see that at the Supreme Court level. The Supreme Courts are going to say, the Supreme Court, the United States Supreme Court often cites precedent, a previous case that they've ruled on to say, well, we've already kind of established that this certain thing is a rule, is a law. It's the correct interpretation of the Constitution. So that's one time that you'll see precedent really being a factor. Essentially, the technical definition of stare decisis is that it's a doctrine that asserts that a previous decision by a court applies as precedent in similar cases until it is overruled. And that's something that we'll talk about. The Supreme Court actually does have the power, actually any court has the power, to try to overturn precedent if they can argue that that precedent previously was not applied correctly. So example would be in the late 1890s, the Supreme Court used the 14th Amendment to justify segregation based on race, creating the infamous concept of separate but equal. Nearly 60 years later, the Supreme Court overturned that decision, which technically would have been precedent, citing again the 14th Amendment, saying actually that court got it wrong. Segregation based on race is inherently unequal. There's no way that you could use the 14th Amendment to do that. They got it wrong. We're going to get it right. That's kind of a big deal if the court does that. So let's move on. Another important term would be jurisdiction. Courts all have their individual jurisdiction. So for instance, let's say you get a traffic ticket in Sacramento County. You would have to go before a Sacramento County court if you wanted to contest it. You wouldn't go to a court in Amador or Placer or Yolo counties. Jurisdiction is all about the scope of a court's power and authority. The United States Supreme Court has jurisdiction over the United States, the entire country, both states and federal. State courts would only have jurisdiction within their state boundaries. Now, there are a few types of jurisdictions. So there's exclusive, meaning federal courts have specific cases that only they try. State courts only have specific cases that only they would try. Concurrent, which means that both state and federal courts can hear a specific case. An example might be some type of hate crime involving homicide. Homicide is usually a state level offense, so the state courts would hear it. But if there's a federal hate crime statute that's being invoked, then it could concurrently be also heard in a federal court system. Original jurisdiction means that the case is automatically going to go to a certain type of court. So for instance, if you had a case involving foreign official, foreign minister, representative, the original jurisdiction for that is the U.S. Supreme Court. So the case would automatically go to the Supreme Court. And then there's appellate jurisdiction. Appellate courts are higher courts. They come in the second level, which we'll talk about in a little bit, after trial courts. So let's go ahead and move on here. Just some background on the structure of the federal courts. They were created by Article 3 of the Constitution. So if you've been following along, Article 1, legislative branch, Congress. Article 2, president. Article 3 would be the courts. And the function of the federal courts is that they hear cases involving federal law, meaning law that's been passed by Congress, or administrative law that's been passed by the federal bureaucracy. They also hear appeals from state courts. So if something goes to a state Supreme Court and the parties involved appeal it, then they can appeal to the federal court level. Typically, it's the U.S. Supreme Court. And the federal courts also are going to review constitutionality. So a state court would not review the constitutionality of the U.S. Constitution. The state courts would only be reviewing the constitutionality of their individual state constitution. But the federal courts, they're going to be looking at constitutionality of the United States Constitution, which would override all state constitutions. A little bit more about the structure of the federal court system. It is derived from the U.S. Constitution, which would be Article 3, and then federal statutes that have refined the structure over time. So actually, Article 3 establishes the fact that you can have a federal court system, and it establishes a U.S. Supreme Court, but then Congress, very shortly after the ratification of the U.S. Constitution, the U.S. Congress had to pass a law actually creating the lower federal courts. Federal courts have jurisdiction over cases involving federal laws, treaties with other nations, or the Constitution. That all goes to federal court. None of that would go to the state courts. Also, they hear a case if the U.S. government is a party in the case, and a civil case, remember that's involving financial issues, between citizens of more than one state and in which more than $75,000 is at stake. So here is the structure of the federal court system. If you look kind of down at the bottom-most level of the little green boxes, especially right there in the middle, the beating heart of the federal court system is those 94 district courts. States can have up to 4 district courts. So here in California, we have 4 district courts. In Sacramento, we're actually in the Eastern District. So if there was some kind of federal law that somebody violated. And typically, in the last 10 years, there have been a lot of federal cases in Sacramento involving mortgage fraud. That would be a federal law. So let's say somebody in Granite Bay committed mortgage fraud. They were selling bad mortgages to people in the housing crisis 10 or 12 years ago. Then the U.S. attorney, who is located in the Eastern District in Sacramento, would bring a case in the Eastern District, one of those 94 district courts, the one that's here in Sacramento, to prosecute that person. So the district courts are trial courts. That's where people can be put on trial for breaking federal law. There are also territorial courts. Those would be in U.S. territories like Puerto Rico, Guam. We have U.S. tax court involving issues from taxes. Then we have a court that is specifically assigned for the District of Columbia, Washington, D.C. Now, if you were involved in a case in one of these 94 district courts or any of these other three little green bubbles, let's say you didn't like the outcome, you wanted to appeal, it would now go to one of 12 U.S. courts of appeals. Okay, that's the second level of the federal court system. And then if the outcome of the case there wasn't satisfactory, you could then appeal to the very top level, which would be the United States Supreme Court. It's important to understand that the U.S. courts of appeals are not trial courts. They do not go through the whole jury process, hearing evidence. Essentially, it's a panel of judges who look at how the case was handled down at the district court level and to see if perhaps there were any errors. And same with the U.S. Supreme Court. These are not trials. The United States Supreme Court does not hear trials. There's no jury. It's all based on the justices to come up with a ruling. Now, over here on the left, you have military courts. So people who are service members, people in the military, if they commit some type of crime, there's a separate branch of the federal court system. There's even a court of military appeals to try people who are currently in the military. Over on the right, you also have a court for veterans appeals. That would be separate than the military courts. You have Court of International Trade and Claims Court. Those all go through the U.S. Court of Appeals for the Federal Circuit, which is located in Washington, D.C. That's a separate, that's the 13th courts of appeal. It's kind of its own separate court of appeal. Moving on here. This is kind of another way of looking at it. It's just another graphic to kind of show you how this works. Especially if you look over here on the right. If you look down at the bottom where it says state trial courts, often known as superior courts or circuit courts. In California, they're known as superior courts, and we'll get to that in a moment. But essentially, this is showing you how there are two separate tracks. Over here on the left, we've got the federal court system going through its appeals process up to the circuit courts, which are the appeals courts. It's another name for them, circuit courts. Over here on the right, we have the state trial courts going up through their appellate courts to the state Supreme Court. And then the very end of the line up here would be the U.S. Supreme Court. And that is, basically the structure of the U.S. court system. It's really made up of two different systems, all of the state courts and then the federal court system. Just to give you a snapshot of the load that the federal court system, or actually the American court system altogether, experiences, how many trials are going on every single year. Take a look at this. In 2010, there were almost 14 million cases happening at the state trial court level. You can see there's a big drop off. That drops down significantly to 160,000, roughly, cases that then get appealed in the state appeal courts. And then there are 75,000 cases that are heard at the state Supreme Court level. That's still quite a lot because there are many, 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 many more trial courts than there are courts of appeal, which means that there are more judges at the trial court level to hear all those cases. To give you an example, we have 58 counties in California. Each county has its own trial court system. We have 6 courts of appeal in California. So all those cases that start at the county level, they have to go up to those 6 courts of appeal, and then there's one state Supreme Court. So even though the numbers are dropping off, you have to keep that in perspective. Over here at the federal level, we had 362,000 trial cases that happen in the district courts in 2016. That then goes down to 58,000 or 59,000 roughly at the courts of appeal. That's still quite a lot. Again, if you're thinking about how there are fewer courts of appeal, that's still quite a lot to handle. And then the U.S. Supreme Court heard 7,500. Now, let me take a step back. That's not how many cases they actually ruled on. That's how many cases were sent to them. Okay, so essentially, if you're a judge, or let's say you're a justice at the U.S. Supreme Court, okay, you're getting appeals to hear cases all the time, every year, but you can't hear all of them. Some of them, especially at the U.S. Supreme Court level, they're not important enough, which sounds really bad, but the U.S. Supreme Court is there to weigh in on the most weighty, important constitutional issues. So it's only going to try to rule on the cases that are going to have the biggest impact to the country, that will also say something about the Constitution. So these are cases that are coming to the courts, but not necessarily being ruled on. Okay, so these are all cases that they come to the courts, but they may get settled, they may get rejected. So essentially, these are the number of cases that people are filing, but they're not all necessarily being heard. Just to kind of go over the system, the federal court system again here. So there are 94 district courts at the federal court level. These are called trial courts. They have original jurisdiction in federal criminal and civil cases. So for instance, a federal terrorism case would go to a district court. So if we had a terrorist case that was prosecuted here in Sacramento, it would go to the Eastern District Court located down there in downtown Sacramento. The next level would be the courts of appeals. Notice I've said there's 13. There are technically 12 that have areas within the country that where their jurisdiction is. But then there's the U.S. Federal Court of Appeals, which is in Washington, D.C. I just added that in. That's why there's 13. This is the layer above the district courts, and they have appellate jurisdiction. So if somebody doesn't like the outcome of their case at the district court level, they would then appeal to one of these courts of appeals. And then finally, the Supreme Court, which is kind of like an appeals court on steroids, that is the highest appeals court in the federal system. This is a graphic that shows how the federal courts of appeals have jurisdiction over certain areas. Okay, so back to our example where we had a federal case in the Eastern District Court here in Sacramento. If you look, the Eastern District is the largest district in California. It goes all the way from roughly Fresno County, all the way to the state line with Nevada, all the way up to the state line with Oregon, and essentially it's the entire valley and northern Sierra. So that's a pretty big district. That's the Eastern District. And then over there on the coast, starting probably roughly right around Monterey County, going all the way up to the state line with Oregon, that is the Northern District. And then there's a Central District and Southern District. Okay, so those are the 4 districts in California. Now, if you had a case in the Eastern District of California here in Sacramento, and you wanted to appeal, you would be appealing to the Ninth Circuit Court of Appeals. Okay, that's the federal appeals court that has jurisdiction to hear cases coming from the district courts, and it's all Western states. And also, they're going to be hearing appeals from a couple of U.S. territories as well. So that would include Guam, Northern Mariana Islands. The states that it would include would be Alaska, Hawaii, Arizona, Nevada, California, Washington, Oregon, Idaho, and Montana. And so the rest of this graphic shows you by number the other circuit courts of appeals. So the Rocky Mountain and some of the Plains states would be in the 10th Circuit Court of Appeals. That's what that 10 symbolizes. We've got a bunch of other Plains states that would be in the 8th Circuit Court of Appeals. Now, a little bit more about this. So there's a bit of a partisan process that goes along with putting judges on these different circuit courts of appeals. And the Ninth Circuit Court of Appeals, which is all of those states and territories that are yellow out there on the west, that includes California, the Ninth Circuit Court of Appeals is known as being a little bit more liberal. The judges that are appellate judges on that circuit court, for some reason, You know, could be a quirk that a lot of them were appointed at a certain time during a Democratic presidency. But the Ninth Circuit Court does tend to issue more kind of liberal decisions. Now, down in the Fifth Circuit Court, that's going to be a much more conservative circuit court, which, it's Mississippi, Louisiana, Texas. That probably makes sense. But again, that's also a quirk of whoever would have been president when they were appointing the judges for that appellate district. So let's say you had a case and you wanted to get, you wanted to get a certain type of outcome. Okay. You're probably going to try to file it in a district court that you can then appeal upwards to an appellate court that's going to be either more conservative or more liberal. And in fact, private parties do try to do that. They will try to find a way to file their cases in a district and appellate district where they think that they're more likely to get a favorable outcome based on their partisan ideology. All right, so here we are at the end of part one of our lecture, and it's time for our first discussion question. You're going to go into Canvas and you're going to answer these two questions. Based on this graphic, would you describe the federal judiciary as diverse? Second question, does racial, ethnic, and gender diversity of federal judges matter? Why or why not? So make sure to post your comments there in the comment field and make sure that you're responding to at least one other student. Make sure to keep those comments constructive and substantive. And I will go ahead and post the second part of this lecture. Thank you for listening.